I've put together a presentation, and thanks to Google Translate, I've also put the Turkish version. So may I just request for the remote. So in my address, I intend to cover the below topics, which I believe have some bearing or the other on effectiveness and efficiency of arbitrations. As Iram mentioned, the most important stakeholder in the entire process is the user. And therefore, I will highlight the measures which the users should adopt and arbitral institutions should adopt to encourage efficiency. I will also throw some light on the role of Indian courts in maintaining a balance so far as autonomy of arbitrations is concerned and interfering only where it is required. I will speak about factors influencing choice of seat. And lastly, I'll say a few words about collaborations between governments, judiciaries, lawyers, institutions, law students to develop best practices of international arbitrations. So speaking of the measures first, and from the standpoint of users, and when I use the expression users, I mean the contracting parties, the first most crucial aspect is for the parties to draft a proper alternative dispute resolution clause, that is the ADR clause. Too often, and this has been my experience, and I'm sure many of you will vouch for this, the discussion regarding the ADR clause is left open until the close of the negotiation. Best practice, however, is to consider this very crucial aspect early on. Each commercial relationship is unique, and therefore, contracting parties are well advised to take proper guidance from legal minds when it comes to drafting of an ADR clause. Connected to this aspect is the need for arbitration institutions to provide model arbitration clauses, incorporating by reference a modern set of arbitration procedures which meets the expectations of the parties can be an excellent starting point for any drafter. In their procedures, the arbitration institutions should provide the option to the parties of a step dispute resolution. In many commercial relationships which are ongoing, and if the parties want to do a negotiation or a mediation before starting an arbitration, they must have that option, because some relationships are ongoing and they are complex. They would not want to straight away go for an arbitration procedure. A poorly drafted arbitration clause may result in a pathological clause, and this is worse than having no clause at all. It is therefore crucial that the arbitration clause that is drafted and that is provided in agreements is clear and unambiguous. Parties must ensure that they have specified the law governing the underlying contract, the law governing the arbitration agreement, the law governing the procedure, and also where the seat is. In situations where these very crucial aspects are left open, contracting parties face unique struggles at the time when they have to decide where the challenge will lie or where the enforcement procedure will lie. It is therefore very important that these aspects are given the due importance that they deserve. Arbitration institutions ideally should come out with a guide to draft an ideal dispute resolution clause. Taking the discussion further from the standpoint of arbitration institutions, there are two other aspects which I believe are pivotal, and one is improvements in administrative support and substantive procedural improvements. When I speak of improvements in administrative support, it is necessary that the case managers have the necessary expertise. Adequate administrative support is provided by the institutions, and this includes a holistic oversight of the arbitral processes, which will then ensure a consistency and a reasonable standard of service to the users, who, as I said, are the most important stakeholders. And creation of databases pertaining to information concerning the arbitrators, how the arbitrators were appointed, the role played by an arbitrator in a panel, what is the status of that dispute, and this is something which is provided by ICC. So most arbitration institutions can gain from that example. When I speak of substantive procedural improvements, it is crucial that the procedures which arbitration institutions provide are user-friendly, simple, and most importantly, cost-effective. The Honorable Supreme Court of India, in a number of decisions, has flagged the indiscriminately high fees charged by arbitrators. And this is a big challenge to the growth of arbitration, not just in India, but in other jurisdictions also. One way to reduce costs and to save time is for the parties to agree to decide some of the minor procedural issues and procedural hearings where only housekeeping issues are involved by virtual mode. This will help the parties to save the costs which they would otherwise spend on a physical hearing. Substantive hearings, of course, where you are addressing final arguments and where you have to cross-examine a witness, should be in a physical mode. But procedural hearings, housekeeping hearings, can be done in a virtual mode. There will be an immense saving of costs so far as accommodation of arbitrators and lawyers are concerned, traveling costs are concerned, various other aspects. There is a big need for administrative and logistical support for virtual hearings. Transparency of administrative processes. More tailored procedures for complex and multi-party arbitrations. Provisions for arbitrators to order both in-person and virtual hearings. Cost sanctions may be for delay in arbitrations. And provisions for secure electronic filing and document sharing platforms. Since speed, cost, and enforceability are the primary concerns for any users, it is important that arbitration institutions innovate and improve accordingly to keep up with changing times. Inclusions of provisions such as emergency arbitrations, early dismissals, expedited procedures should be provided for. Very importantly, it is important to broaden the pool of arbitrators, not just in terms of number, but also ethnic and gender diversity. And there should be a feedback mechanism on arbitrators also. Some arbitration institutions are providing that, but it goes a long way in ensuring how arbitrators are to be appointed. I'll speak a few lines on the role played by Indian courts and generally in arbitrations. And here I would want to say that courts play a decisive and pivotal role so far as arbitrations are concerned. And that role is played by ensuring autonomy of arbitrations and yet interfering where it is required. The basic grundnorm of arbitrations is autonomy, and its entire foundation rests on it. When one looks at the trend of a large majority of decisions from Indian courts, particularly in the recent past, it is discernible that our courts in India are ensuring that a balance is struck. There is no wanton interference with awards. Only in very rare cases where an interference is called for, courts interfere. When parties choose a seat, there is a growing wish that the seat that is chosen must have the judicial facility to implement technological advances. And this is to ensure effectiveness and efficiency in arbitrations. For example, local courts being able to remotely hear virtually, an arbitration related matter. These aspects were not given a lot of prominence in the pre pandemic era. However, the pandemic taught us that these are crucial, and now they're getting the attention that they deserve. I must mention and applaud both the Indian judiciary and the executive, who on their part are ensuring that arbitrations are given the due importance that they deserve. Courts have narrowed the scope of judicial interference when awards are challenged in India. And the executive, on its part, is encouraging the ministries to honor arbitral awards, especially in large infrastructure projects where there are cash flow issues. There are various other factors also which influence a choice of seat. And speaking from my experience, and this may not necessarily be the view shared by others, when two Indian parties are negotiating a transaction, a vast majority of them insist that India must be the preferred seat. Dynamics, however, change when an Indian party is negotiating with a foreign counterpart. And in those situations, the foreign party insists that a neutral foreign territory should be the seat, whereas the Indian party obviously wants India to be the seat. The Indian Supreme Court, in a very progressive decision a couple of years back, has now ruled that two Indian parties can also choose a foreign seat. So I see a paradigm change happening. And Indian parties are also now opting for neutral seats. And as a fellow panelist mentioned, and it was very heartening to know, Delhi being one of the preferred destinations, very good news. Delhi has all the facilities and centers which are as equipped as the center that we are sitting in. And therefore, all of you are most welcome to have Delhi as a neutral seat for your arbitrations. The other key considerations which parties have in mind when they're choosing a seat is the duration in which the awards are rendered. That's one of the key considerations which any businessman will ask. Enforceability of interim orders, whether an interim order which is obtained can be enforced in a jurisdiction, be it India or any other country where the assets may be located. Presence of expedited procedures in institutional rules. Some of the institutional rules provide for expedited procedures. Whether the seat that they are choosing has ratified the New York Convention or the Geneva Convention, because enforceability will depend upon that. Lex arbitri will also determine the behavior of the parties, whether the dispute that they are trying to resolve via arbitration is arbitrable at all. In some jurisdictions, certain disputes are not arbitrable. And therefore, parties keep these aspects in mind. But whatever may be the consideration, it is important that each of these aspects are considered, deliberated, and then the decision is taken regarding the seat. Speaking of collaborations, I must mention that India is a rising star in terms of arbitrations, both on the domestic and the international front. And India has taken and adopted a very proactive arbitration approach. India obviously is taking giant leaps towards becoming one of the leading economies of the world. And therefore, the idea of resolve in India is not a very distant dream. The day is not far, and as I said, Delhi being a preferred destination, the day is not far that India will be one of the leading preferred destinations for resolution of international arbitrations. And in this light, collaborations such as these to develop best practices are critical, because these collaborations ensure that an equitable and harmonious environment worldwide is developed for international arbitrations. Initiatives which can be taken for the benefit of users by arbitration institutions like TOBBUYUM and APCAM are conducting more workshops like these, where people are educated about international arbitrations, taking a more proactive stance in collaborating maybe with law colleges, budding lawyers, encouraging them to take up arbitrations and telling them the benefits of international arbitrations. And of course, having dialogues like these, arbitration weeks, congresses, where all of us can share our experiences and maybe come up with something which is ideal and which suits the requirements of all. That's all so far as my address is concerned. Thank you very much for a very patient hearing, and it is my absolute privilege to be a part of this august gathering. Thank you.
Yes, am I audible now? Thank you so much, Siddharth. I wish Delhi would be the preferred seat and you would be the preferred counsel.